A good day to one and all present here. My name is Pratik, and me, alongside my co host Adit, shall be running through, over the course of the next 10 minutes, the process by which one registers a trademark within India. The registration of a trademark is a multifaceted process that exists that specifically deals with different aspects of the method of the specific trademark that wishes to be registered and begins with the identification of the trademark itself. The identification of a trademark essentially means that the actual trademark that needs to be registered needs to be specifically quantified. What sort of image it is, what sort of graphically succinct process it is, what sort of sound it is, and so on and so forth needs to be clearly defined. And it needs to essentially meet the criteria laid down under section 9, with section 9 being the criteria by which a trademark cannot be given. So when one goes through with the identification of their trademark, they must ensure that it is clearly distinguished and must be in a position to be not refused by the registrar as a whole. Moving on, then, after the identification of the trademark, one must do a trademark search. A trademark search is essentially a process by which a particular product is, or rather, a particular trademark is tested along with the trademarks that have already been registered. Earlier, this used to be an onerous process. However, now there exists a trademark portal that tabulates and lists all of the specific trademarks that have been registered within India. So, a trademark search essentially goes through the trademark portal and analyzes every one of the trademarks that exist in the specific class of the goods that are being trademarked in the present case. When that occurs, and when there is existing no specific differentiation or distinction between any trademark that has already been registered and the present trademark must be rethought. However, if there exists no similarity as such, then one can move on to the next step of the process. The next step of the process being the filing of the application. The relevant sections and rules in this particular matter are Rule 25 and Section 18 when read together, and Rule 128. Coming firstly to Rule 120, to Rule 25 and 18, specifically gives the power to the proprietor to register a particular trademark in the trademark registry, either by way of in person going or otherwise by way of e filing. So, a trademark registry usually exists as a outlet of the exact trademark authority that exists, and by way of e filing implies that one must go on to the government IP portal and specifically fill the forms that exist. The specific forms being the TM1 or the TM51 application. The TM1 application essentially exists if you are trademarking a particular good in a single class. However, the TM51 application exists where there are multiple classes of goods that are to be trademarked for. Now, Rule 128 specifically provides the nature of information that is required in the trademark process. Firstly, it requires the details of the applicant, specifically to ensure that the proprietor is in fact a citizen of India. Secondly, it looks at the details of the trademark. The details of the trademark essentially suggest that the graphical representation of the trademark in question is clearly given. Thirdly, then, one moves on to the priority claims. The priority claims are not applicable in all cases. However, they do exist where you already have a registered trademark in another country. In such cases, when the trademark is being looked at in India, the person who suggests such a trademark has a priority claim to it, as long as such information and intimation is given to the trademark registry. Moving then, one must move on to the next step of the process, which is the examination and response. This shall be taken over by my co host Adit and shall be in detail explained.
Thank you, Pratik. Moving on from where Pratik stopped, before we move on to the examination, there's an important aspect of it that is the advertisement of the part. According to Section 20 of the Act, after an application has been accepted by the registrar with conditions and limitations, it needs to be published in the official trademarks gazette. If within 3 months of the advertisement, no objections arise from the public, it goes on to the next process. However, if there are any objections made from the public as under Section 21 of the Act, the registrar must take into considerations and create a proper report, following which it must consider and ask the aggrieved party to make a counter application as well, repealing the previous application in said manner, and must also permit any correction of errors if necessary. The next step is as I mentioned earlier, the correction of the errors and the amendment. If the registrar feels fit, before or after the acceptance of said application for registration under Section 18, he may permit for corrections of any error that may follow under Section 20, 21, and 22, so on and so forth. If all of this is accepted pertinent to the satisfaction of the registrar, then we move on to section number 23, in which the application, if one, which are not opposed and time for notice of opposition has expired, and two, were opposed but the objection was in favor of the applicant, will be registered. According to subclause 2, the applications will be provided with a certificate in the prescribed form of registration after the trademark registration. Unless the registration of trademark is completed within 12 months of its application, it will be treated as abandoned. Under subclause 4, the registrar is allowed to permit an amendment to the register or the certificate for mending or clerical mistakes, if any. Furthermore, under Section 91A, which means absolute grounds for refusal of registration, and Section 11(3)(a) of the relative grounds of refusal, in addition to a law passing of it, the court may determine the mere abbreviation of words cannot be claimed to have been a trademark or something on those sorts. And finally, if anyone is aggrieved according by the decision of the registrar, they have the chance to appeal the same under section 91 of the act to the appellate authority. And if everything is done according to how it's mentioned, then the trademark can be registered. Thank you.